Magandang araw, class. Hanggang doon lang yun. Kala nyo, totoo, no? So anyway, we will proceed with our lecture on Chapter 3. Today, we will be talking about mortgage. Source materials are the same. So anyway, let's begin. Sa mortgage, remember, this is known as mortgage, real estate mortgage, or real mortgage. They are one and the same animal. So sa isang real estate mortgage, anong ginagawa natin? The debtor secures yung fulfillment ng isang principal obligation, which is usually a loan. So there is a loan contract, debtor borrows money from creditor, and to secure the fulfillment of this principal obligation, the debtor will subject as security an immovable property or a real right over immovable property. Now, if the obligation is not complied with at the time stipulated or the principal obligation is not satisfied within the time stipulated, yung immovable property or yung real rights over immovable property will be sold at a foreclosure sale, and the proceeds in the foreclosure sale of the property sold will be used to satisfy the claim of the creditor. So, if nakabayad naman on time, if the principal obligation is fulfilled, obviously the mortgage on the property will be canceled. So yun ang real estate mortgage. So meron kang utang, you secure payment with an immovable property. Now take note of the characteristics of a real mortgage. It is a real right. It binds, remember, a purchaser who knows of its existence, and also it binds the entire world if the mortgage is registered. Kaya nga siya real right. It binds the entire world. It is a right in rem. What else? Number 2, it is an accessory contract. Meaning, if the principal obligation is void, the mortgage is also void because of the principal accessory follows principal. So, tandaan nyo, kung ang principal contract of loan is void, the mortgage will also be void. So, yun nga, sumusunod lamang yung accessory sa kanyang principal dahil dun nga siya naka-rely. Now, take note also that if the mortgage is void, it can happen that the principal contract of loan may still be valid. It is also indivisible as we have discussed when we discussed yung chapter 1 ng ating topic sa pledge and mortgage. So anyway, hindi ko na i-discuss yan. Balikan nyo na lang yung aking lecture noon kung hindi nyo na matandaan. What else? Take note that it is inseparable. So what does it mean? Yung mortgage follows the property. It does not follow the owner, but it follows the property. So whoever the owner is, the property is still subjected to that mortgage. Kasi nga, the mortgage will follow the property regardless of who the owner is. So let us say, ako, nangutang ako sa inyo to secure my obligation, payment of the obligation to you, sinangla ko yung lupa ko. Later on, binenta ko yung lupa na yon. Same land na sinangla ko sa inyo, binenta ko sa iba. Pwede ba yun, ma'am slasher? Pwede yun. So anyway, ginawa ko nga eh. Eh di pwede. So pwede nga. So, remember, class, that the buyer will buy the property, but it is still subject to the mortgage. So, meron pa rin siyang burden, may lien, may encumbrance pa rin yung property. So, itong buyer is buying with a risk na ano, later on, the property may be foreclosed if the debtor does not fulfill the principal obligation. So, you cannot separate the mortgage from the property. Didikit talaga yan. So, kahit sino pa ang may-ari, kahit ilang lipat pa. So, kahit ilang lipat, if there is an existing mortgage, kung binili mo yan, there is a possibility na makukuha pa rin yan ng creditor and it will be foreclosed in a foreclosure sale, but sold at a foreclosure sale. So what else? It is a real property. A mortgage on real property is also by itself a real property. Kasi nga, lahat ng real rights over real property is also real property. So what else? Number 5, 6, it is a limitation on ownership. So remember, it creates an encumbrance or a lien in the property, but it does not end ownership. So may burden lamang sa property. Nililimit lamang. So ownership still belongs to the mortgagor or to the buyer in case binenta niya ito, but there is a limit dun sa kanilang ownership. Yung impending risk na pwede itong ma-foreclose for non-fulfillment of the principal obligation. What else? It can secure all kinds of obligations, which I have already discussed in Chapter 1. And the property cannot be appropriated, which I already discussed in Chapter 1. Balikan nyo na lamang again kung hindi nyo natatandaan. So what else? The mortgage is a lien. As I have said a while ago, yung mortgage is a burden on the property. It is a burden or a lien or an encumbrance which will follow the property regardless of the owner. So take note that the property mortgage does not need to be in the possession of the mortgagee. Unlike in a pledge, sa pledge, kailangang i-deliver ng pledge or sa pledgee yung thing that is pledged. So, no delivery, no pledge. But in mortgage, remember, the mortgagor debtor, as a general rule, retains possession of the property mortgage. So, itong uh, debtor subjects own the property to an encumbrance only, but ownership remains with the mortgagor. As is the same rule with all contracts of secured transactions. So, kaparehong rule din sa pledge, etc., etc. Only in pledge only possession is given, but not ownership. Here in real mortgage, the property is subjected to a lien or an encumbrance, but the ownership is not given up or parted with. So anyway, what else? It is not essential, however, in a contract of mortgage that the property remains with the mortgagor. It can happen that the mortgagor will deliver the property to the mortgagee. Pwede yon kung yun ang napag-usapan ng parties. So the mortgagee will be in possession, but it will not alter or change the nature of the contract of real estate mortgage. Real estate mortgage pa rin yan. Hindi magiging pledge yan. Di porke dineliver yung property, pledge na kaagad. Pwede pa rin siyang magstay as real. Hindi pwede. Mag-i-stay talaga siya as real estate mortgage because obviously the property involved is an immovable property. So, remember, yung pledge cannot be extended to cover immovables. Kaya hindi talaga magiging pledge yan. What else? Take note here that even if the mortgagee possesses the property, he cannot acquire it by prescription. Kasi ang prescription will apply only if the possession is in the concept of an owner. And plus class, this is registered property. Pagka nakaregister siya sa torrent system, yun yung ating system ng registration ng mga lupa sa Pilipinas. Hindi siya pwedeng ma-acquire ng acquisitive prescription, even no matter how long it is. So what else? Cost or consideration in mortgage, it is the same as the cost or consideration in the principal contract. Kasi nga yung accessory contracts nakadepende lamang sa principal yaan. So, yung cost or consideration, pareho ng cost and consideration ng principal. What else? Subject matter of mortgage will be immovable properties or alienable, ibig sabihin ng alienable, transferable, real rights over immovable property. So again, a real right over real property is also a real property in itself. So a mortgage on real property, ang real estate mortgage is in itself a real property. Hirap ng concept na yun, no? Pero ganun talaga. So, future property obviously cannot be the object of a contract of mortgage due to the lack of ownership. Sa chapter 1 pa lang napag-aralan natin na ang mortgagor and also pledgor must be the owner of the thing pledged or mortgage. So, what else? Kinds of mortgages, voluntary or conventional, created by the parties. As I've already always mentioned, anything that is voluntary or conventional, laging by parties yan. Legal, lagi kong sinasabi, by law. What else? This has to do yung 2082, 2083. This has to do with sa mga bondsman nito, yung mga nagpapiyansa. Hindi ko na masyadong i-discuss kasi talagang out of topic na siya sa inyo. What else? Equitable mortgage, which we have already studied when we studied yung conventional redemption in chapter 7 ng sale. So, here, there is an intention to make the property as a security, even if the contract lacks proper formalities of a real estate mortgage. So, this is alone disguised as a sale. So, yun yung mga equitable mortgage. They did not follow the formalities of a real estate mortgage. So, what else? Essential requisites of mortgage in 2125. So, saan na ba ako? In addition to those that are stated in 2085. Ano na nga ba yung pinagsasabi ko sa 2085? Nung sa chapter 1 pa ito, ma'am, nakalimutan na namin. Sir, nakalimutan na namin. Grabe naman kayo. Kakasabi ko lang last week, nakalimutan nyo na naman. So anyway, in 2085, ang sinabi ko dyan, pledge or mortgage must be constituted to secure performance of the principal obligation. What else? Number 2, yung pledgor, mortgagor must be the absolute owner of the thing pledge or mortgage. Kakasabi ko lang kanina yan, mga 5 seconds ago. And number 3, pledgor or mortgagor must have the predisposal of the thing, pledge or mortgage. So if they do not have predisposal of the thing, pledge or mortgage, or capacity to alienate it, remember class that they should at least have authority, legal authority to pledge or mortgage the property. So, kailangan silang may-ari, meron silang free disposal and capacity to dispose it. Now, kung hindi silang may-ari, wala silang capacity to dispose, let us say in case of an agent, yan, pwede pa rin na siya ang mag-pledge or mag-mortgage if they are legally authorized to do so. Now, in addition to all of that, those three, meron pang requirement in 2125. The mortgage to be validly constituted must appear in a public instrument duly recorded in the registry of property. So take note here, mortgage is always presumed to be valid until the contrary is shown. So sino ang mag-show ng contrary? The party attacking the validity of the mortgage. So ikaw na nagko-question ng mortgage, patunayan mo na siya ay invalid due to fraud, duress, or illegality. So, yung right to attack or right to question is lost by the waiver of defects. May defective yung real estate mortgage. Okay na rin yan kahit defective. Waiver. And also, by unreasonable delay. So, ang tagal, hindi mo pa kura-question. 20 years na yung real estate mortgage. Imposible na yun kasi nag-i-expire ito actually. So, anyway, 5 years na, hindi mo pa rin kura-question. So, it amounts to ratification noong mortgage contract. So, what else? Sabi ko kanina, public instrument. And the public instrument must be recorded in the registry of property according to 2125. Ma'am sir, paano kung mortgage is in a private document? So, meaning it is not notarized. So, remember here, no valid mortgage is constituted. So, if the mortgage contract is a mere private document, and remember, a private document is non-registrable. So, obviously, walang registration, hindi siya valid as a mortgage. So, obviously, also here, that the contract of loan still exists and the creditor may recover yung kanyang money in the contract of loan. So, take note here that yung mortgagee, if gusto niya, he has a right to compel the debtor to execute a contract of mortgage in a public instrument. So this is paragraph 22125 in relation to 1357. This is a right granted to the mortgagee to compel yung debtor to execute the public instrument. So anyway, yung right sa 1357, the right of contracting parties to compel one another to observe the proper form, um, requires that the contract or agreement between them is valid and enforceable already. So, let us say, sale of a parcel of land. So, nabayaran na yung parcel of land, it is already delivered, but it is in a private instrument. Diba sabi ko sa forms, kailangan ang sale of real property or any interest in the real property is in a public instrument to be valid. Pero yan, private instrument. Pero since may bayaran na, at saka meron ng deliveran, it is fully executed document. So here, remember, valid and enforceable na yan because it is fully executed and the contracting parties can compel one another to observe the proper form. So execute a deed of sale in a public instrument so that this deed of sale in a public instrument may be registrable in the registry of property. Ma'am/sir, paano naman po kung halimbawa the mortgage is not registered? So take note here that the mortgage is in a public instrument but the instrument is not recorded. So here, the mortgage is nevertheless valid between the parties. Kasi ang purpose nga lang naman ng registration na yan is to operate as a notice to the entire world or to third persons. So to bind third persons, kailangan ng registration. So kung meron ng public instrument, valid naman yung mortgage as between the parties. Yung pagre-register will not make it more valid. And also take note that if it is invalid mortgage, kahit na successfully maparegister nyo yan, it does not turn yung invalid mortgage into a valid one between the parties. So, yun ang tandaan natin. Valid still, but only between the parties. It will not bind third persons. Now, take note also of the doctrine of mortgagee in good faith. So, here, in case of this doctrine, remember na yung mortgagee or creditor has a right to rely on the certificate of title na ipepresent ng mortgagor. So, itong mortgagor, may dala siyang titulo ng lupa. Tapos, anong gagawin niya? He will give it to the creditor. The creditor will inspect yung title. Pagka nakita niyang legit itong title na to, wala namang ibang encumbrance. Kung merong encumbrance dati, na-clear naman, etc. Kung nakasangla ito dati, na-cancel na yung sangla, na-clear naman. So, anyway, here, in the absence of any sign that might arouse suspicion, wala nang obligasyon ang creditor na mag-imbestiga pa. And also, pwede siyang mag-rely dun sa mismong certificate of title. So, kung it turns out later on that the mortgagor is not actually the rightful owner of the property, or hindi talaga siya entitled to the property, the mortgagee in good faith is nonetheless entitled to protection based on this doctrine. So, yun ang tandaan natin sa doctrine of mortgagee in good faith. But take note also that this doctrine presupposes na yung mortgagor na hindi may-ari ng property ay nakakuha ng titulo, torrents title ang tawag natin doon over the property. And ang galing niya, naparehistro niya sa pangalan niya. And after niyang naparehistro sa pangalan niya, he succeeds in mortgaging the property to the creditor. And the creditor simply relies on the certificate of title presented by the debtor. Tapos nakita niya, walang kahit na anong senyales na pwede siyang magkaroon ng duda. So, yan. Here, remember, he can rely on the said title. Creditor is no longer required to make further investigation. So, innocent purchaser or the mortgagee pala in this case, kasi nga mortgage ang pinag-uusapan natin. Yung meron din kasi tayong doctrine of good faith pagdating sa sale. So anyway, innocent mortgagee for value protected by law is one who purchases a titled land by virtue of a deed executed by the registered owner. Kasi nga naman, class, tandaan nyo na pagka ang nagbenta sa inyo, hindi siya yung nakapangalan sa titulo, dun palang magduda na kayo. So parang mawawalan na kayo ng good faith if you do not investigate further. So obviously, this doctrine will not apply in case yung mortgagor is not the registered owner of the property. So anyway, exceptions to the doctrine of mortgagee in good faith. Number one, purchaser or mortgagee pala, has knowledge of a defect or lack of title in the vendor. So, mortgagee here does not deal with the registered owner of the property and he is aware na merong mga pangyayari na dapat mag-imbestiga na siya. Tapos, kailangang magtanong na siya tungkol sa ano ba talaga ang status ng property na to. So, kung hindi siya nagtanong, he is not in good faith. And also, syempre, dahil may knowledge talaga siya ng defect, direct knowledge of a defect, syempre, hindi na siya pwedeng i-consider as in good faith. Now, number two, mortgagee bank is expected to exercise greater care. So, sa kanila, hindi, pagka sasangla mo yung titulong sa bangko, hindi na nila basta titignan yung titulo. Mag-iimbestiga talaga sila. So, even those involving registered lands in its dealings, in case of private individual, business also, because yung business nga ng isang bangko is impressed with public interest. So, kailangan meron daw careful examination of the title as well as a physical and on-the-spot investigation of the land. So, pupunta pa talaga sila doon, mag-ocular inspection sila ng lupa. Tapos, syempre, pagdating doon, kanino ba talaga, tatanong lang mga kapitbahay, kanino ba talaga itong lupa na to? Sino bang may-ari nito? Sino bang nakikita nyo nandito? Kung may nakapwesto, bakit ka nakapwesto dito? Anong karapatan mo? Ba't nandito ka? So, yun ang mga bank. So, in its dealings with private individuals, they must exercise greater care and prudence. Kasi nga, yun na nga, nakalagay naman dito, the business of a bank is impressed with public interest. So, a bank that failed to observe this kind of due diligence, cannot be accorded the status of a mortgagee in good faith. What else? Due diligence of banks will also extend to persons who are regularly engaged in the business of lending money secured by real estate mortgage. So, yung mga lending, yung mga tao, kahit tao lang, na ang business talaga nila is nagpapahiram ng pera at kumukuha ng sanglang lupa, yung diligence na required of banks is also required uh, with respect to these kinds of persons. What else? Rules regarding registration. Once a mortgage has been signed in due form, the mortgagee is entitled to registration as a matter of right. So, pagka na-execute ng real estate mortgage at saka nanataryuhan na to, pwede nang iparehistro ng mortgagee. So, dahil nga naman in-execute ng mortgagor yung real estate mortgage contract, syempre may consent na siya doon. Or else, bakit siya pipirma? So, dahil may consent na from the mortgagor, syempre itong si mortgagee/creditor can register yung real estate mortgage. Saan? Sa titulo ng lupa. Doon niya ire-rehistro yan. So, pagka nakakita na kayo ng titulong nakasangla, meron siyang nakasulat sa likod or succeeding pages, kasi usually 2 pages lang yan. Sa harap, tapos yung sa likod, yung description ng continuation ng description ng lupa. So, ang gagawin ng Registry of Deeds niyan, dadagdagan nila ng page 3. Tapos sa page 3, nakalagay dun yung real estate mortgage. So, naka-annotate na siya dun. Every time that you will get a certified copy of that, nandun siya, nakatatak siya. Even in your mismong title na nasa kamay mo, nakatatak siya. So, kailan matatanggal yung tatak na yun? Hindi nila buburahin yung nabuburahin na. They will annotate a cancellation. So, they will annotate a real estate mortgage in your title, yun ang registration. So, lalagay nila, inonote nila, this is a mortgage to ganito for the amount of ganito. Lalagay nila sa titulo mo yan. Tapos, pagkaka-cancel na yan, lalagay nila sa baba. Yung mortgage dun sa taas na ganito ang date, cancel na yan. Ganon maglinis ng titulo. So, anyway, basta daw meron ng real estate mortgage contract, pwedeng i-register ng mortgagee yan. What else? Registration is a ministerial act, but not a declaration by the state that the instrument is a valid and subsisting interest in land. So, basta nakanotaryo na yung real estate mortgage, tapos present ng creditor, irerehistro ng Registry of Deeds yan. Pero, hindi ibig sabihin nun, valid yung real estate mortgage mo. Kasi ministerial act lang yan. Kumbaga, ministerial act, hindi pinag-isipan, kailangan lang talagang gawin. Pagka they will exercise discretionary yung act, pag-iisipan muna. So, i-decide kung i-rehistro or hindi. Pero ito, matik. Ito po yung papel ko, public instrument yan. Okay, rehistro. Wala nang isip-isip, ministerial. Yan ang act na yan. But it does not mean that the real estate mortgage is a valid mortgage. So, anyway, questions regarding the effect or invalidity of the instrument or real estate mortgage instrument is expected to be decided after, not before, registration. So, registration is allowed first, tapos validity of the real estate mortgage contract will be litigated later on. What else? Letter C, registered mortgage over property previously sold is inferior to the buyer's unregistered right. A registered mortgage, however, is superior to a contract to sell. So, if there is a previous sale, so remember class that even if there is a subsequent mortgage and the mortgage is registered, mananalo pa rin yung sale previous to the mortgage. So, even if the previous sale is unregistered sale. So, anong mananalo? Yung buyer na mayroong unregistered sale or yung mortgagee na may registered mortgage. Ang mananalo is yung buyer with an unregistered right. Also, take note na pag ang naglaban naman is a contract to sell. Kasi contract to sell pa lang yan eh. Ibebenta pa lang. So, the unregistered mortgage is superior to the contract to sell. So, what else? Effect of invalidity of mortgage on principal obligation. So, principal obligation will remain valid, obviously. Kasi nga, invalidity of the accessory will not affect the principal. So, if the accessory is rendered not null and void, principal obligation, which is guaranteed by the accessory obligation, is not rendered null and void. So, ang right lang na nawawala is the right to foreclose the mortgage as a special remedy available to the creditor. What else? Mortgage deed remains as evidence of a personal obligation. So, syempre sa utang, civil case yung mga ganyan eh. So, ang ginagamit nila dyan is paramihan ng evidence. So, promissory note, in addition to the promissory note, pwede nyo ring i-submit yung mortgage contract as proof na mayroong utang. So, evidence or proof of personal obligation of the debtor and also the amount due to the creditor. So, what else? Effect of mortgage under 2126, it will create a real right. So, ang Article 2126 simply means that the mortgage is a real right following the property, which I have already discussed. So, if a mortgagor sells the property, yung buyer must respect the mortgage. If it is registered, syempre, registered, it will affect third persons, or if the buyer is aware of the existence of a mortgage. So anyway, registered mortgage will create a right in rem, so a real right. So it is, yung liyan na yan is, again, ulit-ulit na ng concept na to, inseparable from the property mortgage. Dahil nga siya ay right in rem, it is enforceable against the whole world. So, personality of the owner is also disregarded. So follows the property wherever it goes. Um, Mortgage must be registered para maging real right siya. So, in case that it is not registered, the buyer of the property must know of its existence, in which case, meron na itong effect of registration as to that buyer who is actually aware of the existence of a mortgage. What else? Number two, it creates an encumbrance. So, number two yan. Hindi ko na i-correct yung aking PowerPoint. So, it creates an encumbrance. So, a mortgage is a security for a debt. And it does not extinguish the title of the debtor. Owner pa rin siya. But yun nga, merong encumbrance na or lien or a burden on the property. So, anyway, we have already discussed that. What else? Non-responsibility of buyer for the deficiency. In case yung creditor forecloses the mortgage in the hands of the buyer. So, yung property binili ng isang buyer. Yung buyer binili niya na may risk na ma-foreclose. Na-foreclose na. So, buyer will not be responsible for the deficiency, if any, for the encumbrance is only on the property itself. Except in case of novation talaga. So, if the parties consent to the buyer's assumption of personal liability due to novation, remember, dun pa lang magiging liable yung buyer. What else? Applicability of the article even if the mortgagor is not the principal debtor. So, obviously, the mortgagor may not be the principal debtor. This is in case of an accommodation mortgagor. So, this article will apply. What else? Transfer of property to another. So remember, class, that the mortgagor can sell the property to a third person even without the creditor's consent. So dahil nga walang consent yung creditor, the mortgagor will still be personally liable. And take note that the buyer will buy subject to the risk of foreclosure. Kasi nga, yung mortgage follows the property, not the owner. Ulit-ulit ko nang sinabi yan. So what else? Extent of mortgage in 2127. It is constituted on the immovable, but it is not limited to the immovable property. Pero included yung accessions, improvements, growing fruits, rents, or income, as well as proceeds ng insurance if ever the property is destroyed or if the property is expropriated by the government. Remember the value of the property dun sa expropriation sale. So, yun ang makukuha, yun ay kasama sa mortgage. So, um, this law is predicated on the assumption na yung ownership ng accessions and accessory will also belong to the mortgagor, who is the owner of the principal property. So, syempre, yung immovable, ang may-ari ay yung mortgagor. So, yung mga accessions and accessories and improvements which are subsequently introduced after yung constitution nga ng mortgage will still belong to the owner of the principal property. So take note also of some doctrines here. Growing fruits naturally should exclude those already harvested before the obligation falls due. So, syempre, kung meron nang na-harvest doon sa property bago mag-due yung obligation, hindi yun kasama sa mortgage foreclosure. Yan. So, what else? If equipment on a mortgage land is temporarily removed, kasi yung equipment kasama yan eh. Kasama sa mortgage. So, if this equipment is temporarily removed, the mortgage will continue on the said equipment. What else? Merong isang case, land with an old house. It was mortgaged. So, later, yung old house was demolished and a new house was built doon sa land. So, it is new, syempre, it is more expensive. So, in the absence of a contrary stipulation, the new house is also covered by the mortgage. So yun ang tandaan natin, some doctrines laid down by jurisprudence. So ito pa pala. All objects permanently attached to a mortgage land or building, although they may have been placed there after execution of the mortgage, are also included. So ito yung mga subsequently acquired, pero they are placed in the property in a permanent manner. So they are also included in the mortgage. To exclude them, express stipulation. What else? Yung tandaan din natin yung dragnet clause or blanket mortgage clause. Pwedeng isama yan sa mga mortgage contract. So, yung dragnet clause or mortgage clause, it is a stipulation in the contract na ang sinasabi diyan is to save time, yan, to save time, travel, loan closing costs, cost of extra legal services, recording fees, etc. Yung property which is mortgaged now will cover also will also serve as security for future loans noong debtor to the creditor. So it makes available additional funds to the debtor without executing another real estate mortgage contract. So, operates as a convenience and accommodation to debtors. So, kumbaga, dagdag lang ng dagdag ng utang. Tapos, pwedeng dagdagan yung utang nga. But yung mga additional sums will be covered by will be secured by mortgage on the same immovable property subject to a dragnet clause or blanket mortgage clause. So, it will secure nga future advancement. So, it will not limit the amount for which the mortgage may stand as security. So, ayun. Usually, ito yung medyo interesting na itanong sa board exam, dragnet clause. What else? A mortgage given to secure future advancement enables the parties to provide continuous dealings. Kasi nga convenient, it is an accommodation to borrowers. So what else? Yun namang alienation or assignment of mortgage credit. So yun ngang mortgage credit is a real right. Diba? Sinabi ko na kanina yon. So it will be subjected to the fulfillment of the principal obligation, and this right may be alienated or assigned to third person. So, the mortgagee may assign yung right niya to other to a third person. 'Di ba yung credit na assign? Di yung mortgage credit na assign din ng creditor yan sa ibang tao. Pinag-aralan na natin yan. So, in in addition to assigning your credit to other people, pwede ring ibenta yung mortgage credit. So the assignee here will collect from the debtor. If the debtor does not fulfill the principal obligation, the assignee may foreclose the mortgage in case of non-payment of the mortgage indebtedness. So, what if the alienation of the mortgage credit is not registered, valid as between the parties? So, what else? Right of the creditor to go against possessor of the property mortgage. Real right following the property. So, mortgage creditor or creditor can demand from the possessor of the mortgage property the credit insofar as it can be obtained from the property itself. So, anyway, yun nga, mortgage follows the property, being a real right. What else? 2130 talks about a stipulation which forbids alienation or sale of a mortgage property. So, this is called your pactum de non alienando. Yan. natakpan ko na naman. So, para ipakita ko sa inyo, i-move ko ng konting sarili ko dito. Ayan. So, ayan, binalik ko na yung sarili ko doon. Kasi gusto ko sa sides. Parang janitor fish. Pagka nagsiswimming ako class, dahil hindi ako masyadong marunong mag-swimming, doon lang ako sa sides, parang janitor fish. Kasi, yun na nga, takot ako malunod. So, anyway, such stipulation, bawal daw ibenta ng mortgagor. Bawal din yan. So, such prohibition would be contrary to public good kasi nga ang transmission of property should not be impeded at yan ay isa sa mga basic rights ng property owner. So, property owner can dispose of his property. Hindi pwedeng hindi pwedeng i-withhold yung right na yan. So, kasi pagka pwede itong mga ganitong klase ng provisions, yung mortgagee can simply withhold his consent and prevent the mortgagor from selling his property. So, sobrang advantage na raw ang mapupunta sa mortgagee. And kung kailangan pa ng consent ng mortgagee para ibenta yung property, it will amount to a virtual prohibition on the owner to sell his mortgage property. Kasi, paano kung never nag-consent yung mortgagee? Hindi na mabibenta ng mortgagor yung kanyang property. So, what else? If the mortgagor alienates the property, obviously, the buyer is bound to respect yung real estate mortgage constituted on the property. So, always buyer's ownership over the property is always subjected to, the property in the hands of the buyer is always subjected to the right of foreclosure of the creditor. What else? Stipulation. Itong mga to, wala na sa book nyo ito. Stipulation granting the right of first refusal. Ano ba yung right of first refusal? So, under the right of first refusal, valid ito. So, here, yung mortgagor will first notify the mortgagee of his intention to sell the property. And the mortgagor will give the mortgagee priority over other buyers. So, bago ibenta ng mortgagor yung lupa niya sa third persons, i-offer niya muna first to the mortgagee. Creditor, baka gusto mong bilhin na itong lupa na nakasangla sa'yo bago ko ibenta sa iba. So, that can be a stipulation which you can include in your real estate mortgage contract. And this stipulation is valid also. So, anyway, take note na offer muna ng mortgagor to the mortgagee and let the mortgagee refuse first. Kaya nga, right of first refusal. Now, if the mortgagee refuses to buy, that is the only time that it can be offered to third persons. So, any sale made in violation of the right of first refusal is rescissible. So, yun ang tandaan natin, pwede ang right of first refusal. What else? How about stipulation requiring prior consent of the mortgagee before subsequent mortgage? So, tandaan nyo ang isang mortgage property, immovable, pwede pang i-mortgage uli sa iba. Kasi di ba hindi naman required ang delivery. Unlike in pledge. So, pagka na-pledge mo na sa isa, hindi mo na pwedeng i-pledge sa iba. Ito pwede mong isangla as many times. As long as your creditor, as long as any other creditor is willing to risk na merong mga naunang mortgagees kaysa sa kanya. So anyway, this stipulation requires na bago isangla ng mortgagor ulit to other persons, yung original mortgagee should consent. So this stipulation is valid and binding. So what else? 2131 talks about foreclosure. So, foreclosure is a remedy. Yan. Available to the mortgagee and it subjects the mortgage property to the satisfaction of an obligation. How? You will sell the property at public auction. And after selling the property, may nagbid, yung proceeds niya will be applied to the payment of the claim of the creditor/mortgagee. So anyway, take note of the effect of foreclosure. it is valid only when the debtor is in default in the payment of his obligation. Di ka pwedeng mag-foreclose kung hindi pa default ang debtor, ha? Tandaan nyo yan. Huwag kayong masyadong excited. What else? General rule, demand before foreclosure is essential. Siyempre, to give the debtor an opportunity to pay for the obligation. Baka mamaya may pambayad naman talaga. So, i-notify mo before foreclosure. What else? Right of foreclosure cannot be exercised by any person other than the creditor, mortgagee, or his assigned. So, creditor, mortgagee can exercise yung right to foreclose, and if the creditor, mortgagee uh, assigns yung mortgage credit, yung kanyang assignee can also exercise yung right of foreclosure. What else? Foreclosure must be limited to the amount mentioned in the mortgage document. Common sense. Only the proceeds, once the proceeds have been applied to the payment of the obligation, the debtor cannot anymore be required to pay. So, unless, syempre, there is a deficiency between the amount of the loan and the foreclosure sale price. So, yun ang tandaan natin. So, mayroong recovery kung mayroong deficiency judgment. So, what else? Only rights. The only rights which a mortgagor can legally transfer after the foreclosure of the property is the right to redeem. So, remember in Chapter 7 of Sales, we talked about the right of legal redemption in case of foreclosure, which is 1 year from the registration of the certificate of sale. So, kung naibenta na yung property sa foreclosure sale, yung debtor mortgagor can redeem the property within 1 year from the registration of the certificate of sale. But this right to redeem can also be sold. So, tandaan nyo, mortgagor can legally transfer, cede, and convey the right to redeem the property foreclosed. So, pwede ibang mag-redeem. Basta ibinenta ng debtor slash mortgagor yung kanyang right to redeem dun sa third person na yan. So, kung pwedeng i-assign ang mortgage credit, pwede ring i-transfer ang right to redeem. What else? Mortgagee may take steps to recover the mortgage property to enable him to enforce or protect his foreclosure right. So, if he is unable to obtain possession for sale on foreclosure, kailangan daw niyang mag-file ng civil action to recover possession or to obtain a judicial foreclosure. So, syempre, di ba hindi naman kasi kailangang i-transfer yung possession sa real estate mortgage. So, it can happen that yung creditor cannot obtain possession para sana i-public sale niya. So, in such case, ang pinakamagandang remedy ng debt creditor here is to obtain a judicial foreclosure. Mag-file na lang siya sa court ng petition para magkaroon siya para mag-order ang court ng judicial foreclosure. What else? Foreclosure proceedings are presumed to be regular. Burden of evidence to prove irregularity is on the party challenging yung validity ng proceedings. What else? Kinds of foreclosure may be judicial. So, judicial foreclosure is an action for foreclosure that is brought before the regional trial court of the province or the city where the real property or any part of the real property lies. So, magpa-file pala ng, di pa petition, complaint pala. So, complaint, it shall order the mortgagor to pay the amount due on the mortgage debt. So, pagka nag-hearing to class actually. So, pagkatapos ng hearing, syempre, if the creditor, mortgagee, is able to prove the existence of the debt, sa decision ng court, the court will order the debtor to pay yung kanyang obligation. So, pay the amount due upon the mortgage debt or obligation with interest and other charges within a period of not less than 90 days nor more than 120 days from the entry of judgment. So, if the mortgagor does not pay within the time directed by the court, yung court pwedeng pwede kasing mag-motion, hindi pwede, magmo-motion talaga. Magmo-motion talaga yung creditor. So, magre-request siya sa court na yung property may to be sold at a public auction or foreclosure sale. So, syempre, sa public auction na yan, dun ibebenta ng sheriff yung property. Pagka benta, mag-i-issue ang sheriff ng certificate of sale. Yan. So, in the absence of a certificate of sale, no title passes by the foreclosure proceedings to the vendee. So, kailangan kulitin nyo si sheriff. Kung ikaw yung nakabili sa public auction, sheriff, mag-issue ka na ng certificate of sale, etc., etc. So, what else? In addition to that, if there is a balance due to the mortgagee after applying the proceeds of the sale ordered in a judicial foreclosure, the mortgagee, yan na, is entitled to deficiency. So, merong deficiency judgment. So, if the entitlement to the deficiency is embodied in the judgment of the court, dun sa decision ng court, it is referred to as a deficiency judgment. So, third person is a mortgagor. Yun nga, sinabi ko na to kanina, he is not liable for any deficiency in the absence of a contrary stipulation. So, action for recovery or deficiency must be directed, against the debtor. So, anyway, application, paano ba ina-apply ang proceeds ng sale? Bayaran muna ang cost ng sale, amount due to the mortgagee, so bayaran ng utang sa creditor, and claims of persons holding subsequent mortgages in order of priority. So, sabi ko sa inyo, pwedeng isangla ng maraming beses. So, yung unang pinagsanglaan, yun ang babayaran, sumunod, kung may natira, sumunod, kung may natira pa, sumunod, etc. in order of priority. And, kung meron pang natira, kung sakali, to the mortgagor. So, in a mortgage, not only is the creditor entitled to recover deficiency from the debtor is also entitled to the excess. Yan. So anyway, extrajudicial foreclosure naman, pursuant to the rules of revised rules of civil procedure. So these are the 2019 amendments to the 1997 Rules of Civil Procedure enacted May 1, 2020. So, bago-bago to. Kahit kaming mga lawyers, nangangapa kami sa bagong ito. So anyway, extrajudicial foreclosure is available only if there is a stipulation in the contract. Kailangang i-allow ang mortgagee or i-grant ang mortgagee ng power to foreclose the mortgage by an extrajudicial sale of the mortgage property. So, hindi ka na pupunta sa court dito. But, kung ikaw yung creditor, you must be empowered or authorized by the debtor to sell the property extrajudicially. What else? Statutory provisions governing publication of notice of mortgage mortgage foreclosure sales must be strictly complied with. So, sa rules, revised rules of civil procedure, tandaan nyo, meron silang ang civil procedure is ano bang tawag dito? Para mas madali nyo maintindihan. Ito yung procedure to be followed para sa mga court cases, ganyan. And also in case of foreclosure. So, marami tayong rules eh. In case of expropriation, meron tayong rules. In case of adoption, meron tayong mga rules. So, lahat ng mga procedure na yan, nasa rules of court. Yan ang buong tawag dyan. So, anyway, here we are specifically talking about the rules on foreclosure. So, anyway, kailangan daw yung mga provisions of law regarding yung publication of notice ng foreclosure sale, kailangan daw i-comply. So, even slight deviations from the notice requirements will invalidate the notice and render the sale at the least voidable. So, anyway, sa extrajudicial foreclosure, kailangan mayroong written notice of sale. And the written notice of sale is, yun nga, sasabihin lang niya na, mga pre, binibenta na to. Ganun. Notice of sale nga eh. It shall be given to the judgment debtor at least 3 days before the sale. So, oy debtor, bebenta na namin yung property mo. So, that is a notice to be given to the debtor. The notice will specify the place, date, and exact time of the sale, which should not be earlier than 9 a.m. nor later than 2 p.m. So, may schedule. Oh my goodness. Anyway, notice of sale also, in addition to giving to the judgment debtor this notice. This notice must also be posted for 20 days in at least 3 public places in the city or municipality where the property is located. Sheriff's Office, Assessor's Office, Registry of Deeds, and yun daw ang mga public places contemplated by law. Also, publication is required when the assessed value of the property exceeds 50,000 pesos. So, the notice of sale, 50,000. Alam ko 50,000 pesos yan. Sige na nga, para sure. O, di ba? Ang galing ko. The notice of sale shall be published once a week for 2 consecutive weeks in one newspaper selected by raffle. Nira-raffle ito sa basta ira-raffle. Usually sa court niraraffle. So anyway, the purpose of the publication of the notice of sale is to inform all persons of the date, time, place of the foreclosure sale so that they can also bid doon sa sale na yan. Anyway, sale at public auction is held within the intervening period anytime between 9 a.m. to 2 p.m. This is valid without regard to the duration or length of time it took the questionnaire to conduct the proceedings. So, kahit gano'n pa katagal, halimbawa 2 p.m. nagsimula, lumagpas, basta within the intervening time. So, it does not matter kung ano yung duration or length of time para matapos yung proceeding. What else? The contents of the notice. Ito yung bebenta na yung property mo. So, it must contain the correct number of the certificate of title and also technical description of the real property to be sold. What else? Take note of a term upset price or tipo. This is a stipulation in the contract of real estate mortgage which fixes a tipo or upset price at which the property will be sold at foreclosure proceedings. So this is a stipulation setting a minimum minimum price para sa pagbebenta ng property sa foreclosure proceedings. So this stipulation is null and void. Bakit? Kasi sabi sa Rules of Civil Procedure, property mortgage should be sold to the highest bidder. So, even if the contract of real estate mortgage contains an upset price or tipo, the sale of the property must take place and the property is awarded to the highest bidder. So, right to recover deficiency, sinabi ko nga, against the debtor. So, debtor must pay the remaining balance of the obligation. And what else? Action to recover deficiency after foreclosure prescribes after 10 years from the time the right of action accrues. So, meron kang 10 years para i-recover yung deficiency. What else? Redemption naman. So, matapos ibenta, i-redeem naman. So, transaction by which the mortgagor reacquires or buys back the property which may have passed under mortgage. So, naibenta because of foreclosure, syempre, pwedeng i-buy back ng mortgagor yan. So, mortgagor or owner is allowed to repurchase or buy back the property within a certain period of time. So, anyway, it is allowed in case of foreclosures, also in favor of banking and credit institution, and also in extrajudicial foreclosure. So, redemption, buyback, repurchase. Yan. Pinag-aralan natin to sa conventional. Actually, pinag-aralan natin to sa redemption. But here, this is an instance of legal redemption. So anyway, kinds of redemption, may dalawa. Equity of redemption, right of the mortgagor to redeem property after his default but before the sale, foreclosure sale. So, ito yung intervening period. Nag-default na siya, tapos hindi pa naman nabebenta sa foreclosure sale. So, if he will redeem the property, ang tawag dyan is equity of redemption. So, even if there is already a public sale, pero it is not yet confirmed by the court, pwede pa rin i-exercise yung equity of redemption. So, what else? Also take note of the right of redemption. Um, right of the mortgagor to purchase the property within a certain period after it was sold for the purpose of paying a mortgage debt. So, mortgagor who wants to redeem the property should pay the amount of the loan and also um, not 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 the amount pala not pay the amount of the loan at the time the sale was made. And remember, class, not the price of the property, not the price at which the property was sold. So bayaran niya kung ano yung amount ng utang niya nung time ng sale kasama ng interest, hindi yung amount ng pagkakabili ng property, kasi it can happen that the property will be sold at a much lower price kung walang bidders. Ganun talaga. So, ang babayaran ng debtor here to recover his property is the amount of loan, not the price at which it was sold in the foreclosure sale. So, anyway, what else? In cases of extrajudicial sale, mortgagor may redeem the property anytime within 1 year from and after the date of sale. So, there is a registration of the certificate of sale. Tapos, 12 months. Meron siyang 12 months. So, kung hindi nagkaroon ng redemption within the 12-month period, magkakaroon na ng consolidation ng ownership on the part of the buyer. So, what else? In case naman of banks, so based on the General Banking Law of 2000, judicial mortgagors like partnership and corporations have only 3 months to begin from the date of foreclosure sale, but not after the registration of the certificate of foreclosure sale, whichever ever comes first to redeem the property. So mas maikling time ang binibigay para sa mga partnerships and corporations to redeem yung kanilang property that was foreclosed in a foreclosure sale. So anyway, that's it for mortgage. Please stand by for our last topic sa ating course. As in, buong course last na to, chattel mortgage. So anyway, thank you class and have a good day.